An idea itself can be protected. Well, first of all, you want to keep it secret. That preserves your options. If you don't keep it secret, you're probably going to have much less options than if you do keep it secret. And then you decide, is it eligible for a patent or not? An idea itself can't be protected by trademark or copyright. Patent or trade secret are your only options. And sometimes you have some of both, and sometimes you decide to just do one. So it's a strategic decision that I recommend you work with an attorney to figure out. If someone's using your brand, then first thing you have to find out is, do you actually have exclusive rights to that brand? You might or you might not. If you've done the preparation work, then you're very likely to have strong trademark rights, and then you can work with an attorney to send a cease and desist letter. You can send it on your own, but it's usually more effective when someone gets a letter from an attorney saying, you've got to stop what you're doing or you're going to get sued. If you're not sure if you have it protected, go to an attorney first, because what can happen is that you could send them a cease and desist letter, and then they could say, well, wait a second, we have stronger rights than you, and they could turn around and sue you. So finding out if you really have the first rights and how strong those rights are is really the first step. If your invention is new, non-obvious, meaning there's really an inventive step over what's been published before, and it's useful in a legal way, then yes, you can get a patent for an invention. Yes, it's highly recommended that you use a non-disclosure agreement. The patent application filing system in the United States is now a first to file. It still is a first inventor to file, but what can happen is if you disclose the invention to someone else, it gives them the opportunity, if they're not honest, to claim that they're the inventor and file a patent application. If they have signed an agreement with you, it will be very easy to prove that they got the idea from you. It's highly recommended that anyone you share it with, whether it's your spouse, your mother, or your best friend, business partner that you would trust with your life, have them sign an NDA. And it may seem ridiculous, but having that practice and making sure it's documented, and also it helps them understand that you're treating this seriously and you need them to keep it confidential. So you do want to use a non-disclosure agreement whenever you're disclosing your invention prior to it being put on the market, published as a patent application, and even if you have details that are, after you get a patent, you will have some documents and details that you still need to keep secret. If you have 3D CAD files that are prepared to be used to manufacture your invention, that goes far beyond what the patent application will say. So if you have those files, even though you have a patent, maybe even though you've already got it out on the market, anyone you share those with, you should still have a non-disclosure agreement with. As I mentioned before, to obtain a patent, your invention, what you apply for, needs to be new, not obvious, and useful. But also, you need to be the inventor. If somebody else has created a patent, then you're not an inventor. The inventor is the person who first conceived of the idea with enough details so that it could actually be accomplished. And so if somebody else came up with an idea, you can't patent it. And if something has been published, and all patents that are issued have been published, then the idea doesn't qualify as new anymore. So anything that has been patented can't then be patented again. There's no renewal for a patent. When a trademark is listed as dead in the United States Trademark Office, that means that whoever applied for it either was rejected and never received a trademark, or they received a trademark and it has either lapsed because they did not renew it, or it's been through some kind of cancellation proceeding. You want to be cautious. You might see a trademark that's dead, and without looking further, you might decide to use that trademark, only to find out that the first person who applied for that trademark was sued by another company, and you're walking into the exact same trap. The other thing that can happen is someone may let their trademark go accidentally. It's once every 10 years. That's hard to keep track of if you don't have a good system or help. So sometimes companies lose track of that, or individuals, and they become expired and show up as dead. But that person is still using that trademark. If you start using that trademark, you may actually be at risk of them coming back and reapplying. And trademark law, whoever gets the priority is based on who used it first. So if a company is still using a trademark, even though their trademark is listed as dead, it's not actually available. So the cost to protect an invention has several different elements. It's recommended first you go through the research process to do a research on, has this been published before? Is it new according to the Patent Office standards? Then you prepare a patent application and file it in the Patent Office. 90%, or it's around 90% of patents are rejected at least once in the Patent Office. And so their additional cost is going to be for attorneys to work through that rejection, identify what elements of the rejection are solid, so we need to change what we apply for in the Patent Office, and what parts weren't properly done. And so legal arguments and procedural arguments need to be made to show that the Patent Office didn't properly reject it. And then after that's all done, there's actually an issue fee, and it's highly recommended to go through a review process to make sure there aren't any errors that would be costly to fix in the future. So with each of those pieces, one thing to compare it to is like a car. If you ask, what does a car cost? Even if you're just looking at new cars, there's a huge range of costs. So some of those costs are going to be involved in how complex is your invention, what is your strategy? You can have a strategy that actually ends up with multiple patents that could protect you really well. That's going to cost a lot more than a really simple patent. One other factor is, are you applying for a utility patent application? And usually when people ask, that's what they're asking about. Utilities are how it works. There's also design patent applications that are how it looks. So design patent applications are a lot cheaper, and you can do both. Utility patent applications take a lot more work. And the 90% rejection I mentioned is for the utility patent applications. I don't have the statistic in front of me on what the rate is for design, but I'm confident the rejection rate is a lot lower. So I like to compare it to the cost of a car, because you do get what you pay for. If you're paying less than $10,000, it's going to be a lower cost patent, and it might be lower quality. A good strategy for a business might involve $100,000 or more of different patents, going through processes, and doing all these things. So it's quite a range. When you want to protect your brand, as I mentioned with patents, the first thing you want to do is research. Determine, is that brand actually available? Now, protecting the brand really has two parts. One is registering for the rights and obtaining those rights. And then the second one is actually defending those rights and making sure that nobody else is using your brand. You may be aware that some companies spend a lot of money and effort on their brand. McDonald's, Nike, the famous brands, they put significant effort and money to protect their brand. And so part of that protection cost is the cost of suing people when they infringe the brand. And even before they sue people, they have services and systems set up to watch to see if somebody else is applying for something or has registered an LLC or has put up a website or a Facebook page. They're looking for all of those things if any of them infringe. So the first part of obtaining the trademark is usually less than $5,000. And in vast majority of cases, we can do it for less than that, even if we have some challenges. A lot of trademarks, if we've done really good research, will go through the trademark office without a rejection. Sometimes even if we do good research, somebody that we didn't think was a problem will raise their hand and say it's a problem. When you're going through the trademark process, if somebody objects, and there's a certain period in the process where they get the opportunity to object to you having that trademark, then they can start a trial-like process. It's all done on paper, but it's still both sides are trying to prove their facts and how their facts apply to the law. So in a lot of cases, it's less than $5,000, sometimes even a couple thousand to get the trademark secured. Then there's the ongoing cost of monitoring, sending cease and desist letters, and potentially suing people to actually protect that trademark. And there's the possibility, even as you go through the process, of having a court battle with proving who's first. So those all factor into it. Some trademarks, I'm confident that's $30,000 are spent just to obtain the trademark because of objections and having to fight a legal battle. Others go through very easily. And one other factor, if you pick a name that is going to be highly descriptive of what you do, it's going to cost you more to obtain that trademark and to enforce it. If your trademark has a high amount of description, other people are going to likely use it in ways you don't want them to. That's going to take a lot more litigation effort. So part of the cost of protecting a trademark is, what is that trademark like? And if you work with a trademark attorney like myself, we can sit down, and when you're discussing potential trademarks, we can come up with a strategy and figure out which one fits your long-term goals. I recommend coming with maybe 10 different potential trademarks, and we can work through them in a strategy session. So the costs can vary. Sometimes they're low for quite a while, but you want to be prepared to actually spend money to protect it and defend it. And if you don't spend that money, you may never have a problem, but if you do have a problem, you probably aren't ready for that problem. When you apply for a trademark and it has a person's name that's living, they have to give permission. But that name also needs to be able to work as a trademark. If your name is Ronald McDonald, I don't think you're going to get a trademark because the McDonald Corporation will find it confusingly similar if you use that name, even if that's the name your parents gave you when you were born. So your name still has to be distinguishable as a trademark and not confuse anyone or potentially confuse other people as to whether it's associated with someone else's brand. So even with your own name, you want to do research and determine if that can be a brand. There actually isn't a such thing as a provisional patent. There is a provisional patent application. Provisional means temporary, so it is a temporary patent application. The patent filing system is a first inventor to file, and so the filing date is critical, especially if two people are working on a solution to the same problem. If you know this is an industry problem that people are trying to solve, whoever's first will get the rights. And a provisional patent application is a lower bar to jump over to get into the patent office. It has fewer requirements to be accepted into the patent office, and so it can obtain a filing date in the patent office, and it can be prepared quickly. There are risks in using a provisional. Since it's a lower standard, there might be things missing that you're going to want later, and having those missing might cause you serious problems. And also, it does expire after 1 year. It never becomes a patent by itself. You never go from provisional to a patent. You have to go to provisional to non-provisional, which means not temporary, and then you can get a patent. Or you can just start with a provisional application. It really all depends on your strategy. And that's one of the things we work at in our law firm, is to discuss with small businesses their strategy so that they can make a good strategy and get the timing and the costs and everything to line up with their business plan and their business goals. Invention is considered patent pending when it has a pending application in the the patent office. It's the Patent and Trademark Office. So when you file a provisional or a non-provisional patent application, it is pending until that application is either considered abandoned in the patent office, or if it is granted and becomes an issued patent. So one of those two things has to happen before it's considered not pending anymore. A patent application, even if it's rejected multiple times, you can ask for additional review and keep it pending. You can file another patent application that makes some changes and it can still be pending. And you can actually file, when your patent is approved before it's issued, you can file another patent application and continue that patent pending. And there's some strategy to that, and we cover those strategies, and we make sure we give our clients the opportunity to use that strategy if it works for them.